So, Ms. Heiss, I'm going to ask you some questions. Do you have a written lease with Mr. Bako
Yes, sir.
or Bako? Okay. And is that lease still in its terms, or is it month to month now?
Neither. He has moved out.
He has moved out. Okay, he's already vacated.
Correct.
Okay, now I've looked. You're now just looking for money. Then is that correct?
Correct.
All right. And do you know when he vacated?
February 1st,
All right. And how much is monthly rent?
1900.
Is there a late fee?
$10 a day, but we max out at 190 for the month.
Yep. And so he's already vacated. Let's see. And you have the key. All right. And on your complaint here, bear with me.
The hearing begins with the judge addressing Miss High and asking whether there was a written lease agreement with Mr. Bio. She confirms that a lease did exist. The judge then asks whether the lease is still active or if it has converted into a month-to-month agreement. Miss High explains that neither applies because the tenant has already moved out. The judge confirms that Mr. Bio vacated the property and asks when that happened. She states that he moved out on February 1st. The monthly rent under the lease was $1,900. The judge also asks about late fees. Ms. High explains that the late fee is $10 per day, capped at $190 per month. At this point, the case becomes focused strictly on unpaid money, since possession of the property is no longer an issue.
I believe it appears to be 2215. This was filed in January. Obviously, he vacated by the end of the beginning of the month here in February. So last time he paid rent.
December.
Okay.
No, sorry. Yeah, it was in December, but for December because December was late as well.
Okay. And so he's made that, was that payment in full?
Not really. He didn't pay all the late fee, but I let it go.
Okay. So he's really just missing for January. And I guess then you're looking for a late fee for January as well.
Correct. And that one day in February for the overstay.
Okay. All
and
right.
the court costs.
Yeah, I got it. 1 month, 1 day. Late fee. All right. Let's hear from Mr. Bako. Is it Mr. Bako or Bako? Or neither?
Either one's fine.
Well, I would want to make sure don't want to keep saying it.
Bako.
Well, Mr. Bako, I'm going to ask you some follow-up.
The judge reviews the complaint and confirms that the case was filed in January. Since the tenant moved out at the beginning of February, the dispute centers on unpaid January rent and a small portion of February. The judge asks when Mr. Bio last paid rent. Miss High first hesitates, but then confirms that the last full payment covered December, although it was late. She explains that he did not pay the full late fee for December, but she chose to let that portion go. Therefore, the only unpaid rent is for January, plus 1 day in February. She also seeks late fees for January and 1 additional day for overstaying into February. The judge summarizes it clearly. 1 full month and 1 extra day are owed.
Again, did you vacate on the 1st of February 2026?
That is correct.
Do you have do you have a lease rather with the Miss Heiss for $1,900 a month?
Yes, I do.
And was it a $190 late fee?
No, not $190 late fee.
It was $10 a day, but tops out at $190.
She was charging $15 a day.
$15 a day. Okay. Well, we top it at 10%, so that's fine. Last time you paid rent?
December.
All right. I know you sent quite a bit of information over to us regarding your answer. I just want to give you an opportunity to tell me exactly what's going on. I know you've already vacated here, so we're not going to give a writ. We're only looking for money. So what's going on?
Well, I mean, as far as rent goes, I've paid. Obviously, it's only for 1 month, and this was filed in the middle of January, and the late fees were already sent to her. I sent $290 to her in January. That had to do with any late fees. So that was done earlier in the month. I did notify her I was going to be late about it. Long story short, I have rented for 1.5 years in total. And
The judge then turns to Mr. Bio to confirm the key facts. He agrees that he vacated on February 1st, 2026. He confirms that the lease required $1,900 per month. However, he disputes the late fee calculation. He claims the landlord charged $15 per day instead of $10. The judge clarifies that the lease caps late fees at 10%, meaning $190 maximum. Mr. Bio confirms that his last rent payment was for December. The judge gives him the opportunity to explain his side of the story, emphasizing that the case is now about money only. Mr. Bio begins explaining that he already sent $290 in January to cover late fees. He says he informed the landlord about paying late and had generally maintained communication during his tenancy.
out of that year and a half, as you can see from the evidence, I started renting in January 2024. From February 2024 all the way till November, there were constant breaches to my quiet enjoyment. Everything from construction. At some point, I even had to go live upstairs with her, and at some point, I got uncomfortable. The construction was ongoing, and I had to find and move out for about 3 months. It was 2 months and some. So my entire time there, from February to December, literally for about 11 months, every month something was happening. There were many times where she would come in and need things from the basement. There have been a couple of times that she came in with no authority. And as you can see in the evidence as well, there is evidence where she even said that based on me signing the lease, she doesn't need any of my approval.
Mr. Bio explains that he rented the unit for approximately a year and a half, starting in January 2024. He claims that throughout most of his tenancy, there were ongoing disturbances that interfered with his right to quiet enjoyment. He describes construction issues and states that at one point he had to temporarily relocate upstairs. He says the construction lasted for months and caused discomfort. According to him, nearly every month involved some kind of disruption. He alleges that the landlord frequently entered the basement area and sometimes accessed a space without proper authority. He also claims she stated that she did not need his approval to enter due to the lease terms. He further alleges she moved and discarded some of his personal property.
To come into my place. She's come in, she's touched my personal property, moved things, thrown things away, and yeah, so I am looking.
When's the last time she's entered the property?
January 30th or 31st. Actually, I'm sorry. February 1st, actually. And I had to call the police. Yeah.
So the day that you moved out, she came.
I was already in the process of moving. The only reason I didn't move out on Saturday was because it snowed.
Well, what I'm asking then is, you tell me how she came and interfere with your quiet enjoyment. I know you say you moved out that day.
Even before that, actually. Before that, she had come in at some point in January. So that was the second instant. She wanted to show the property earlier in January, and she had come in a couple of times. And at some point, I set some boundaries.
Were you there when she came in?
I wasn't there. I wasn't there once. And she had touched my property, and I complained about it, and she made it seem like it wasn't.
In what way did she touch your property?
The judge asks when the most recent entry occurred. Mr. Bio states it was around January 30th or February 1st, the day he was moving out. He claims he had to call the police. He explains that earlier in January, the landlord entered to show the property to prospective tenants. He says he requested notice before showings, but believes she did not properly provide it. He alleges that she entered while he was not present and handled his belongings. Specifically, he says she threw away incense and other personal items. He claims that after these incidents, he felt uncomfortable and began searching for a new place to live. Eventually, he moved out.
I have these incense, and there's a whole background around that. I have some of my incense and some other things, and she took them and threw them away. And she wanted to show the property, and I had told her to give me some notice, but that wasn't happening. So I decided to tell her I wasn't comfortable with that arrangement anymore. And she stated that she didn't need my permission. And so she, from my knowledge, just went ahead, showing it to other people. At that point, I found alternative living situation
Okay.
and would come in sporadically.
All right. So what are you're claiming damages here, a counterclaim associated with the past due rent that you owe?
Well, yeah, the past due rent and my quiet enjoyment damages.
Okay. And how have you
Were,
been damaged?
were
You said that those things were thrown away, and you say you know for sure she threw them away. Is that what you're saying?
yeah, she admitted to it.
Okay. And what were the value of those things?
Well, really, the value to me was there really isn't a value I could put on it. There was something special about those incidents to me, and it had.
The judge asks about his counterclaim for damages. Mr. Bio argues that he suffered damages due to violations of quiet enjoyment and loss of personal property. When questioned about the value of the incense that was allegedly thrown away, he admits he cannot assign a specific monetary amount. He says the value was sentimental rather than financial. The judge presses him about why he failed to pay January rent. Mr. Bio explains that he felt he was not fully living in the unit and also feared losing his security deposit. He claims that because the landlord still held his deposit, he believed paying January rent would result in losing even more money. The judge makes it clear that unpaid rent must be addressed regardless of those concerns.
More sentimental value.
Sentimental, yeah.
Right. Rather than just so there really isn't a real value to it. She didn't throw all of them away. It was one.
Okay.
So,
Well, why didn't you pay in January then?
well, the reality was this. Usually if I'm not gonna have it on time, I tell her exactly when I'm gonna have my payment.
Yep,
And
yep.
I always do.
Mhm.
In that month, I had told her when it was, and
Mhm.
then before that happened, she had started showing this the property, and that was when she threw my stuff. She threw something. That was when we started having these issues.
Uh-huh.
And so I had moved out, and then it started getting a
So
bit
wait, I'm just
aggressive.
and I'm letting you talk, but I'm just
Yeah.
asking a specific question here. Why didn't you pay
Well, I did.
January? It doesn't. I know you've mentioned things that
The
happened in
reality,
2024, but obviously that's
yeah.
almost a year and a half
Why I didn't
ago
pay
now.
January was at that point I felt like I wasn't living there long enough, as much as I would enjoy. I wasn't
Right.
there as much as present. And two, she had kept my security deposit before, and she still has it. And
Mhm.
so I felt like if I had paid for January.
The judge then asks Miss Hyde to respond to the accusations. She firmly denies entering the property without permission, except for one emergency situation. She explains that one morning she smelled smoke and believed her home was on fire. Since the tenant was renting her basement, she feared the entire house was at risk. After receiving no response from knocking, she unlocked the door and entered. She states that she found Mr. Bio asleep on the couch while a pot burned on the stove. She describes the burner glowing bright orange and food splattered across the kitchen. She says she recorded a video for evidence because she was concerned about potential liability. According to her, this was the only time she entered without explicit permission, and it was for safety reasons.
In full, she would again keep that deposit, and I wouldn't get my money back again.
Okay.
So
Well, let me speak to Ms. Heiss just to confirm some things. So, Ms. Heiss, I just want to confirm. Obviously, he has indicated that you've entered the property without notice several times, and that he's been damaged. My greater concern, though, is he's saying that you've removed or threw away some of his property. I wanted your response to that.
Sure. So first of all, I've never entered the property ever in either time that he's leased from me without his permission. I've always text him and said, is it okay, if I get something out of storage or whatever? And he always said, that's fine, no problem. So I've never entered without his permission. That's not true, except for a few weeks ago. I woke up at 7 a.m. to thinking my house was burning down. And I'm searching all over, like trying to figure out what's burning. I'm like screaming for my kids, what's burning? What's burning? The house is burning. Something's burning.
Mm-hmm.
Finally, I open the door. It's coming from downstairs. So I'm knocking, I'm yelling, hello, hello. He didn't answer. I thought nobody was down there and my house was on fire down there. So
Mr. Bio denies falling asleep and leaving the stove on. He requests to see the alleged video. The judge states that while the video may be relevant, the primary issue remains unpaid rent. The judge notes that Mr. Bio admitted he did not pay January rent. The sentimental value of incense, without clear proof of financial damage, does not offset rent owed. The judge explains that security deposits are not substitutes for rent payments. They are meant to cover property damage or other legitimate deductions. Because Mr. Bio vacated less than 30 days ago, the deposit issue must be handled separately according to legal notice requirements. The counterclaim fails due to lack of measurable damages.
I run back upstairs, I get the key, I go down, I unlock the door and go in to see him passed out on the couch. And the kitchen, there's a pot burning and food exploded all over the kitchen and the pot is burning. So the only time that I've ever entered his unit without his permission was when he almost burned my house down. Okay.
And these
So
are connected units. He's renting like a basement or the lower
it's
level.
my basement. It's my basement. So he could have killed my whole family. And thank God I was home, and thank God I did go in and I have video of it. I took video of me entering the unit because he was starting to get real weird, of me entering the unit, the burner on high, it's an electric stove, so it was bright orange, the pot burnt to a crisp, and food exploded all over the ceiling.
I got it. And so, Mr. Bego, what's your response to that?
I would love to see the evidence.
I sent him the video.
Wait, I'm just asking you. I don't need to see evidence. Did you fall asleep on the couch and let a pot
No, I didn't.
burn? I mean, these things happen. It's not I'll be frank. I've done it before. I mean,
I haven't.
But
I mean, it just so happens.
The discussion briefly turns unusual when Mr. Bio claims the incense was custom-made using ashes of deceased individuals from West Africa. The judge questions the legality and relevance of that claim. Ultimately, the judge declines to entertain further arguments about incense. The focus returns to unpaid rent and late fees. Mr. Bio insists he paid $290 in January toward late fees. Ms. High confirms receiving that payment, but does not recall the exact date. The judge decides to credit the $290 toward the total owed. The landlord also requests court costs, including filing fees. The judge clarifies allowable costs and recalculates the total judgment accordingly.
Somebody that's had to come in, but did that happen?
It just so happens I've been there a year and a half, and on the month that we're having issues, in my last month, a couple of these things happened. You know,
I'm just asking.
It didn't happen. No,
oh, it did not happen. You did not leave a pot on the stove.
I did not.
Your Honor, may I send you the video right now? I can send it to you immediately.
You could send it to my clerk. I mean, Mr. Bacon, I mean, if she's got a video of you, and I get it.
Please send it. Please send it.
I'll be frank though. Honestly, ma'am, it's relevant, but it's not that relevant. More importantly, though, you haven't paid rent, man. Whatever your reason and what you've told me thus far hasn't extended to the period with me believing. You can't even really give me a value to your sentimental valued sense. So I'm going to give a money judgment. Obviously, it's going to be for the month, 1 day, late fee. There's no writ of possession because you're already gone and she has possession. And that'll be it. I hate that it's gotten this far.
I mean, what happens to my security deposit?
Well, again, as I mentioned earlier, your security deposit is not rent, folks. Let me just be clear about that. It is a deposit to protect against either damages or other things. And the goal really is for people to get it back. But your deposit, if you have a money judgment, I mean, that's depending. She still have to give you certain notices to determine whether or not there are any other damages to the property. But yeah, that's for another time, because again, this hasn't even been 30 days since you vacated.
And what happens to my counterclaim?
Well, you haven't proven any damages, sir.
Well, is it just to put an amount to my? I mean,
yeah, but there still has to be a real amount. She's saying she didn't throw away your cents. You said she didn't throw away all the cents. Now you're telling me, well, I don't really know what the value is. It's
She
really
didn't say
difficult
that.
for
She
the
didn't
court.
actually
Well, Miss
respond
Heist,
to
forgive me. Miss
touching
Heist, did you throw
my
away his
property.
incense?
I threw away ashes.
Ashes.
He was burning incense on the table, and the table was covered with ashes. And I told him, I asked him, this was in his last month of the lease. I have a clause in the lease that says occupant agrees to cooperate with owner agent in showing property to prospective tenant prior to termination of occupancy.
Okay.
I ran it by him. I said, I'd like to show the unit tomorrow. He said, okay, that's fine. I went down there before the prospect got there, and it was an absolute disaster. And the only thing I did was clean the incense ashes off of the table so that the prospective tenant didn't see trash and ashes everywhere. That's all I touched, ashes from incense.
Okay. Well, Mr.
So,
Bishop.
wait.
I have a question, Your Honor.
Okay, yeah.
Yes, sir. Go ahead.
Okay, so are we just dealing with what has been dealt with the last month, or for the entirety of my lease?
Well, I don't
Because,
think
like
the
I said,
relevance
it's
of the
not the
entirety of
first.
your lease at this juncture is really applicable because most of those issues
Okay.
have been resolved. Obviously, if you had other issues, it would have been great to bring those up during those periods. But saying, hey, Judge, 2 years ago, she broke something, but I've continued to pay rent and I've continued, and we've had this unresolved.
Okay.
Those are important. It just depends. At this juncture, what you've alleged and what you're talking about to me is some incense. She's saying they're ashes. I'll be frank. You've already vacated. You've admitted that you've not paid rent. What you've mentioned to me at this juncture doesn't really give rise to a significant amount. I think best that I can do, and honestly, in all lieu of what's going on, if you're saying, hey, she took my incense and swept up ashes, which I really don't amount to much more than that. How much you pay for the incense, brother? How much you pay for them?
It's not just about
Nope.
I paid for them.
How much did you pay for them? You're not injured. You're not going to get pain and suffering.
These are custom made. Okay, they're made with the ashes of people who died. From
really?
Where I'm from. So
they made from ashes. Yeah. Is that even legal? Can you have burned people's ashes of people that have died?
In West Africa, we do that. Yes.
But we're not in West
Africa.
Right,
but I did
we're
bring
in
them
Atlanta.
in from West Africa.
So listen, I'm not going to hear no more foolishness. I'm going to give you a judgment. Listen, it's okay. It's going to be 2153.33. You're already vacated, so you don't need to worry about a writ of possession. And that'll be a plus.
What about the $290 I have paid? What about the $290 I have paid?
The $290 as far as
$290 in late fees.
Okay, well then that would be for the late fees.
In January.
My understanding was for December.
No, there were no late fees in December. They weren't paid.
Then why were you sending late fees in January?
This was for January because I told her I usually tell her exactly what I'm going to pay. And I told her
when did you pay these late fees in January for prepaying late fees?
Yes, I could tell you the exact date. Hold on one moment.
Your Honor, how about the court costs?
Again, Ms. Heist, did you receive an additional $290 from him in January?
Yeah.
When did you receive this $290?
I don't have that written down. I'd have to look at bank records.
Mr. Bako, when did you send her the $290?
I would like the 377 in court costs, please.
Court costs are not 377.
This was on the 15th.
Okay.
Well, the court costs are 177 and my filing fee was 200.
All right. I'm going to do what I know I'm going to do based upon the evidence been presented, since you've identified that you did take the 290. But that was before the actual writ, so that means for the action was filed, so that's fine. So I'm going to have an 1863 because I am going to deduct that 290 because that's associated with monies that he has paid.
Okay, I'm going to just check my records and make sure that's the correct
Well, you already
amount.
admitted that you got it. You're just saying you don't remember the day that you got it. So it's going to be 18. Listen, it's going to be 1863.33. It will be plus court cost with 9.75% interest associated with the judgment amount. Again, there's no writ, and that's going to be my order. I appreciate you guys' time, though, and you guys are free to go. You'll get a copy of it in your email. Thank you.
Okay, so that will have the total amount in it?
It'll be the 18 plus court costs. So whatever the court cost is, my clerks will make sure that appropriate amount has been assessed as well. Okay.
Okay, and what about my fee for filing for my
Again,
time?
it's just, again, you're not a lawyer. You don't get lawyer fees. You get court costs. And
My
that's what I'm
time's
giving you.
valuable.
And so is mine. And I'm going to let you guys go this evening. Thank you.
Can you just tell me how this works in regards to me giving the security deposit back less
And
fees?
I'll be honest with you, ma'am, I'm not your lawyer, but you are required to give him notice regarding keeping the security deposit or any part of the security deposit.
Okay,
All right.
so that's just a completely separate thing.
It is a completely separate thing. Yes, ma'am.
Okay, thank you.
No worries. All right, you guys are both free to go.
In the final ruling, the judge announces a monetary judgment of $1,863.33, reflecting unpaid rent and deductions for the $290 already paid. Court costs are added, along with 9.75% interest on the judgment amount. Since the tenant has already vacated, there is no order for possession. The judge reminds both parties that the security deposit must be handled separately under proper legal procedures. Mr. Bio asks about compensation for his time, but the judge explains that only attorneys can recover legal fees. The court session concludes with both parties dismissed. The judge expresses regret that the dispute escalated but emphasizes that unpaid rent and lack of proven damages determine the outcome.